Welcome to the deep dive. We're here to take complex info and really break it down into something useful. Today, we're tackling a really significant legal situation. It affects, well, a huge number of people. The Cuban Adjustment Act, and specifically this form, the I-220A. Now, the Cuban Adjustment Act, that's from 1966, it's supposed to offer a path to permanent residency, a green card, after just 1 year in the U.S. But there's this technical issue with the I-220A form that's become a massive obstacle. We're talking possibly 550,000 Cubans facing this by 2025. So our mission today, let's unpack this whole intricate legal mess, figure out the conflicting views, and see what it means for the people trying to navigate it all. Okay, let's start with the main problem, this I-220A thing. The Cuban Adjustment Act, the CAA, it all hinges on whether someone was inspected and admitted or paroled into the U.S. Simple enough, right? But there's a catch with the I-220A.
Right. And it's a fascinating catch, legally speaking.
Yeah.
U.S. Citizenship and Immigration Services, that's USCIS, they don't see the I-220A as formal parole. They get a parole under the main immigration law, Section 212D5A.
Yeah.
That clearly qualifies you for the CAA.
Okay, so what do they call it then?
They classify it under a different section, 236A, as basically a release from custody, sometimes called conditional parole. And that difference in label, that distinction, is why they're denying so many CAA applications. It sounds like a small detail, but the impact is enormous.
Wow. Just a label difference shutting down this major pathway. And I understand there's some recent court rulings making it even more complicated.
Exactly. This is where it gets really interesting and, frankly, confusing. You have two major Board of Immigration Appeals, or BIA, decisions from 2025, and they seem to clash.
Two conflicting precedents. How does that happen?
Well, in May 2025, there was matter of QLI. That decision suggested that for people classified as arriving aliens, getting an I-220A should count as parole as a matter of law. So initially, that looked like maybe a positive sign, a way to argue these should be treated as parole.
Okay, so that sounds hopeful.
But here's the twist. The Department of Homeland Security, DHS, they've actually seized on QLI. But to argue against releasing people, they're using it to deny bond and keep people detained.
Wait, hang on. A ruling that seems to support the idea of parole is being used to keep people locked up?
Precisely. It's a real paradox. And then, like throwing fuel on the fire, just a month later, in June 2025, came matter of Roque Azada. This one did two things. First, it confirmed only USCIS can grant CAA status, not the immigration courts. Second, and critically, it explicitly said the I-220A does not satisfy the parole requirement for the CAA.
So QLI hints maybe yes, Roquezada says definitely no, and DHS uses QLI to detain people. That sounds like absolute legal chaos.
It's created a very difficult situation. You've got the highest administrative body on immigration law seemingly contradicting itself within a month.
So what on earth does someone do if they have an I-220A and want to apply for residency under the CAA, given these opposing decisions?
Yeah, that's the key question, isn't it? What's the strategy? Well, lawyers are trying to use QLI. They're appealing the USCIS denials. One tactic is filing a motion with an immigration judge. You argue, look, under QLI, my client I-220A is parole. But you have to expect DHS to come back hard, citing Roquezada. Some lawyers are even including what they call an anticipatory response in their motion, tackling both cases head-on.
That sounds risky.
It is. There's a real concern about redetention. If you argue you have implicit parole based on QLI and that argument fails or is somehow revoked, ICE could potentially detain you again.
So what's the safer bet?
The general advice seems to be, apply for the green card, the I-485, citing QLI. If, or more likely when, USCIS denies it, appeal that denial using Form I-290B. It keeps the case moving within the system.
Okay, the I-220A is clearly a minefield. Are there other avenues people are taking? Maybe avoiding this specific form issue altogether?
Absolutely. Asylum is a very common route for Cubans. The approval rates were reasonably high in 2025, maybe 60, 70%.
How does that compare to the CAA process besides the I-220A problem?
Well, asylum provides protection, which is crucial. But a big difference is travel. Generally, if you get asylum, traveling back to Cuba is heavily restricted, if not impossible. The CAA, if you can get through it, leads to permanent residency, and after that you have more freedom to travel. So because the CAA path is so blocked by this I-220A issue, many feel pushed towards asylum, even if the fit isn't perfect.
Does it feel like the system views these paths differently, like the intentions behind applying?
That's a really interesting point. You could argue the system sometimes seems to interpret the choice of application type. Pursuing the CAA, especially given the travel benefit, might be perceived by some within the system as, let's say, more opportunistic, seeking residency and travel freedom, whereas asylum is often framed, rightly or wrongly, as solely about seeking protection from harm. It's a subtle perception issue, but it can feel like it's part of the background noise.
Right, so many layers. To understand how this plays out, maybe we should quickly map out who holds the power here, who makes these calls.
Good idea. You've basically got two main departments involved. First, Homeland Security, DHS. That includes ICE, who handle arrests and detention, USCIS, who decide on benefits like green cards, and CBP, Customs and Border Protection, usually involved at the border.
Okay, so DHS is enforcement and benefits. Who else?
Then you have the Department of Justice, DOJ. Under DOJ, you have the immigration judges, the IJs, who hear cases in court. And above them, the Board of Immigration Appeals, the BIA, which handles appeals and sets those precedents we discussed, like Cula and Rokizada.
And is the BIA the final word?
Not necessarily. The Attorney General, the head of the DOJ, actually has the power to step in, certify BIA decisions to themselves, and even overturn them. We saw this happen notably in 2018 with matter of Castrotum, and there have been similar interventions impacting cases in 2025 as well. It adds another layer of, well, potential unpredictability.
So it flows from ICE potentially arresting someone, USCIS deciding on an application, the IJ hearing the case, the BIA reviewing, and maybe the AG stepping in before it even gets to federal courts.
Exactly. It's a complex chain. And you can see how criticisms arise. People might see ICE as focused on enforcement, USCIS as bureaucratic or inconsistent, and maybe IJs feeling pressure from the BIA or AG above them.
So wrapping this up, what's the big takeaway for you, the listener? This whole situation with the Cuban Adjustment Act and the I-220A form really shows just how incredibly complex and, frankly, changeable immigration law is. A single definition, a single form's interpretation can impact hundreds of thousands of real lives.
Absolutely. It highlights this constant tension, this interplay between the laws as written, how agencies interpret them, how courts rule sometimes conflictingly, and even how an applicant's reasons are perceived. It's a continuous challenge for anyone navigating this system. So maybe something to think about is, how does this constant shifting, these layers of authority in these legal battles impact that basic human search for stability and security? What does that reveal about the system itself?